Starting with the land-related laws in other states, Bihar has three kinds of land systems during British rule. The permanent settlement system introduced by Lord Cornwallis was applicable for major portion of the entire area. In some areas, land settlements used to be done on temporary basis for a specific periods, and there were also some lands that were managed entirely by government. Such lands were known as Khas Mahal. Agricultural Income Tax Act was introduced in Bihar in the year 1938. Bihar Land Reforms Act was brought in the year 1950. This abolished the system of zamindari system. Now, during 1953, ownership of the entire land of Bihar was taken over by government. State Tenancy Act was introduced in the year 1957. This act provided full rights to tenant farmers holding less than 1 acre of land. The state government enacted Land Ceiling Act during 1961, according to which a government was permitted to retain possession of not more than 20 acres of land irrigated by canals or 60 acres of non-irrigated land. The Act of 1961 underwent amendments in 1973, 76 and 82. In the meantime, farmers were encouraged to come forward on their own for land ceiling. A Tenancy Act was introduced again in 1986. The provisions for sharecropping in Bihar Tenancy Act 1885 had a significant impact on land administration in Bihar. Bihar enacted Sharecropping Act in 1957. If a tenant farmer has been cultivating a land continuously for 12 years, he gets a right of occupancy on that land. This act was amended by Bihar government in 1970. After this amendment, the tenant shall not have any right on the land whose owner has the right of ownership for 5 acres of irrigated land or 10 acres of non-irrigated land, or whose owner is blind, leper, paralyzed, lunatic, widow, or serviceman. Now for Uttar Pradesh Land Revenue Act was enacted in the year 1901. Later, Uttar Pradesh Tenancy Act was passed in 1926 and 1939. The most significant initiative in the area of land reforms in Uttar Pradesh after independence was taken there by the then state government in form of Uttar Pradesh Zamindari Abolition and Land Reforms Act of 1951. Under this act, the earlier classification of farmers was abolished and the farmers were now classified in 4 new categories, that is Bhumidar, Sirdar, Asami and Adivasi. The Act went through amendments in 1954, 56, 58 and 77. In the meantime, government made consolidation of holding obligatory in 1953. Land Ceilings Act was brought in by government in 1960. Few farmers only were holding major chunks of land in some of the regions in the state. The Act allowed any farmer to hold only a definite extent of land. Under land ceiling provisions, the government permitted any landlord to hold between 1960 and 72 a maximum of 16.19 to 32.37 hectares, and after 1972 a maximum of 7.3 to 18.25 hectares of land. Uttar Pradesh government has implemented a new revenue code during 2016. With this, earlier Land Revenue Act of 1901 was made ineffective. As per this code, a landowner belonging to the scheduled caste in the state shall be able to register his land without any permission if he has settled in a place different from the region in which his land is located, or he has been suffering from any life-threatening disease, or he does not have any successor. Now, in Madhya Pradesh, there are 2 land schemes in Madhya Pradesh during British rule. First, it was the Rayyat-based arrangement in some areas, and second, in other areas, the person ensuring recovery of rent was rewarded with a commission of 25% of the collected rent. The rights of a Rayyat over his land used to automatically dissolve to his heir, and he did not have any right to transfer ownership of the land. The Madhya Pradesh government introduced a Land Reform Act in 1951 for the purpose of improvement in land management. This abolished the zamindari system in Gwalior, Indore, Malwa estates. In 1953, the then government enacted Gram Panchayat Act. Land Revenue Code was introduced in 1959. These provisions prohibited any kind of land lease. Arrangements were made for consolidation of lands with agreement of 2 or more landowners. Later, Land Ceiling Act was enacted in 1960. Now in West Bengal after independence, the first change in tenancy in West Bengal was made in 1950 through the West Bengal Pargadar, that is Batidar Act. This provided that a Batidar and a landowner could have any kind of agreement in respect of sharing of the crop, but in case of any dispute, the batidar would get 2/3 of the crop and the landowner would get only 1/3 of the same. The act also permitted any landowner to remove any of his batidars. The West Bengal States Acquisition Act was passed in the year 1953. The main purpose of this act was to eliminate intermediaries between state and its Rayyat. West Bengal Land Reforms Act was introduced in the year 1955. Under its provision, landowners were entitled to get possession of his land back from the tenant for the purpose of cultivation, but this provision was not applicable in the case where the tenant was in possession of the land less than 1 hectare. Now, this act also provided for consolidation of the land with consent of 2 or more landowners. With the amendment in 1971, the ceiling for land holdings were further lowered and a family unit was made the basis for the same. Later, with amendments brought in the year 1986, land ceiling was made applicable for all kind of lands. Now, no family could hold land more than the prescribed ceiling for both agricultural and non-agricultural land put together. Now, in Odisha, after independence, the Odisha state government introduced the State Evaluation Act in the year 1951. By this act, the role of intermediaries between the government and the Rayyats were completely eliminated. The Land Reforms Act was introduced in the state government in the year 1960. This act had the provisions to prevent ejection of a tenant cultivating a land by his landlords before a definite time period. Arrangements were made for assistance from the government for helping the poor tenant farmers to get ownership rights on the land. Provisions for lease for sharecropping, but such sharecroppers were not marked as tenant farmers. Later, land ceiling was introduced under the same provisions were made to limit land holdings to 8.09 to 32.37 hectares from 1960 to 1972 and to 4.05 to 18.21 hectares after 1971. Another Land Reform Act was introduced by the state government in 1972. Under the same, Rayyats could enjoy full Rayyatri rights on his entire holding. The act also made consolidation of land compulsory. Thus, after observing the land system in different states of India after independence, it becomes clear that ownership of the major portion of the entire land was concentrated in the hands of a few. Common farmers were fully exploited under Zamindari system. Hence, the government in different states went ahead with abolition of Zamindari system, implementation of land ceilings, and introduction of provisions to eliminate intermediaries between the government and the farmers, provisions for full rights to Rayyats, and implementation of land consolidation. That'll be all for land-related laws.